Welcome to episode 89 of the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. As we continue our journey with the podcast, we're getting closer to episode 100. I'm very excited about that, perhaps in about close to 2 months now. So as we started about a year and a half ago. Today I'm going to be talking about litigation. And we're going to talk about what to do when things go wrong in the litigation process. Let's face it, sometimes cases are lost. It happens to everybody, or sometimes there are rulings that don't go your way. And not many attorneys are prepared to talk about that. And I want to talk about that today and what to do when that happens, and perhaps suggestion how to handle those instances that take place. Litigation is a process. It's not linear. And what happens is that people have this idea that you will have a lawsuit and all of a sudden everything is going to go your way. There are going to be at least 25 or 30 different hearings throughout the litigation process. And some of them are not going to go your way. That doesn't mean that you lost the case. That means that perhaps that particular order, that motion did not go your way. And I'm going to give you specific examples. And what I find out is that sometimes clients panic when they see an order coming in, order denied or granted for the other side. And there's no reason to panic. It's simply a motion. It's simply a ruling. And there are going to be a series of rulings that will take place throughout the course of a lawsuit all the way to trial that you have to get used to. And it's important that you prepare yourself for potentially having rulings not going your way. And your attorney will explain to you, or should explain to you, the significance of that ruling and what does it mean. Sometimes there are rulings that really not that significant. Some rulings are significant. Some orders are significant and can change the course of the litigation. So I'm going to talk to you today about some of those and tell you how to handle them, give you suggestions how to handle them. It's up to you and your attorney. I'll tell you how I handle them. But I want you to understand that in every single case that I've been involved with, there's some rulings that do not go my way. And we adjust. You have to adjust to whatever rulings come your way. And there's some times that you have everything that you have, prepare yourself, you have every single case law. You should get that motion granted for you, for your client, and it sometimes does not happen. It goes to the other side. So instead of giving up and panicking, you adjust. And you should be able to learn to adjust. Your attorney should be able to adjust to those bad rulings. So let's give you more specific examples. And I think mental preparation is going to be very important here. So I'm talking about, what to do when things don't go your way, and be prepared for delays, for setbacks, and some procedural challenges that you will face throughout the course of the litigation. So let's get started. When a case usually begins, say whether you are suing someone or someone is suing you, usually the first thing that we look for is, can we file a motion to dismiss on this particular case? So I'm going to give you the example of if somebody suing my client. So I'll look at the actual lawsuit and I say, well, are there technical defects in this lawsuit that will allow me to begin to chip away at this lawsuit, or partially or completely, and begin to push back on the defense strategy? So that's the first thing that I look for. And there are a lot of different analysis that I go through, whether the person has standing to sue my client, whether statute of limitation has expired, whether the type of theory of law that they're suing on, whether it's a breach of contract claim, fraud, breach of fiduciary duty, whether the facts that they're alleging support the elements of the claim. So it's a lot of different analysis that as litigation counsel we go through to see if we can begin to file that motion to dismiss. In some cases, we file it and we succeed. So that's the first thing, that if you're being if you're being sued, that's the first thing that I do with respect to a lawsuit. Can I move to dismiss this claim? Likewise, if you're suing someone, very likely the attorney who's on the other side is going to be doing the same thing. They're going to looking at, okay, what can I do to attack the pleadings? In a motion to dismiss in Florida, we have to go strictly within the four corners of the complaint. What does that mean? Meaning that we cannot bring anything else outside of what is written in the document. We cannot bring evidence. There's some exceptions in terms of jurisdiction, but I'm not going to go into that right now. But you basically can technically attack this lawsuit. So when I file a lawsuit to someone, another party, a defendant, our objective is to make sure that the lawsuit survives a motion to dismiss. In some cases, the other party still files a motion to dismiss. Listen, there's always a good chance, 50-50 chance the judge may agree with you. Say they filed a motion to dismiss in this particular lawsuit, breach of contract claim, and the judge agrees with it. The judge says, you know what, maybe it might be an element that was missing from the allegations. It could be something, lack of specificity, something perhaps the judge say, you know what, I think we will dismiss this claim, this lawsuit. But usually what happens is when that initial dismissal comes in, it's without prejudice, with leave to amend. What does that mean? The judge says, okay, we will dismiss it without prejudice, meaning that you can file it again, and we'll give you, say, 20 days for you to amend that lawsuit. And then you amend it, you fix it, and then you submit it again. 9 out of 10 times that lawsuit will survive that motion to dismiss the second time. In some cases, it happens that the attorneys usually meet and confer beforehand. And in Florida, we're required to meet and confer. And they say, I'm about to file this motion to dismiss. Do you want to get into an agreed order that dismissing the lawsuit without prejudice, and then you can amend it in 20 days. And listen, we're not perfect. Sometimes we miss something. You're like, okay, you know what? We'll go ahead and do that, and we'll go ahead and get it amended. So my point to you is that when you see a motion to dismiss coming to you, or an order dismissing the claim without prejudice, doesn't mean you lost the case. It only means that you get a second chance to fix it. And that's all it means. So I just want to share that with you. In contrast, if you see something called a motion for summary judgment, that's what is called a dispositive motion, to the extent that if that particular motion is granted to the other side, say they're filing a motion for summary judgment against you, and the other side wins that motion, that means you lost the case. So it's important to understand the impact of the types of motions that you're actually facing, and your attorney needs to explain to you how important they are in your case. Usually motions for summary judgment are done much later in the case, after the parties have had the opportunity to gather evidence, written discovery, interrogatories, and they also have had the opportunity to take some depositions. Then all that information is put together in this document called a motion for summary judgment, and it basically telling the court, we really don't have to go to trial. You have all the information here to make a decision in this case, because the facts are undisputed as to this case, and this is the reason why we believe you can enter that order. The other side has to file a response and counteract that evidence that was presented by the first party. And then based on that information, based on those pleadings, the judge will render a decision. Now, the judge can go out one way or the other, of course. But and I don't go here in another rabbit hole. A motion for summary judgment means if the judge believes that there are no issues of material fact, meaning that the facts as they're presented, the other side A, has not been able to overcome those facts. Number two, will not be able to. Then the judge very likely will grant a motion for summary judgment. On the other hand, if the judge believes that there's some contradictions here, would say, for example, with testimony that has to be presented at trial, then that motion most likely will be denied. But it's important to know that that particular motion is very significant because it can mean the end of the case. It's not easy to get those motions, but it's not also impossible to be able to obtain those motions for summary judgment. If you receive a motion like that in an order granting summary judgment, that is significant, and then you have to discuss with your attorney, what is the next step here? What can I do to overcome this? And there are a number of options. A number of options might be to appeal that decision to a higher court. Another option is try to negotiate a settlement, but your attorney will explain to you what are those options that you have in light of losing the case. Another motion that is very common that we deal with frequently are objections to discovery or motions to compel. Oftentimes, we send what is called interrogatories and requests for production of documents to the defendant, and we ask a lot of information. If it's a breach of contract case, usually, or some partnership dispute, usually financials are involved. Usually some type of discovery for financial documents are involved, or say subpoena to bank records are involved as well. So it is very common for the other side, the opposing party, to file what is called an objection to a specific discovery request. So in a case like that, then the attorneys will speak and say, how can we resolve this without having to go to the court? Number one, we're required to do so. Number two, it's good practice to do so, simply because it is more cost effective to have a conversation with the attorney as to how can we resolve this versus having to schedule a hearing with the court and have the judge have to render a ruling one way or the other. So to the extent that we can try to resolve it with the opposing counsel, number one, we're required. Number two, it's a good practice to do that. Say we cannot resolve it. Say we're asking for bank records and the other side does not want to provide them, or vice versa. So we go to the court and we schedule a hearing and a motion to an objection to discovery. We explain to the judge what is circumstance. In my case, say why I'm objecting to the bank records simply might be overly broad. They might be relevant. We can provide them with some redactions, for example. The other side wants everything. And I'm just using this as an example. Say in the court decides, you know what, they're relevant and likely to lead to discover admissible evidence. Yes, you can issue a subpoena to the bank, for example. So in that case, we lost that particular objection. The other side can obtain those records. In a case like that, you can create other safeguards, agreeing to a confidentiality order to make sure those documents are only used in the context of litigation. You can ask for attorney's eyes only. There's a lot of different, safeguards that we can put together in order to mitigate the potential damage of getting all those bank records out. So there are things that we can do. Again, there's no reason to panic. If there's an objection to a discovery that is overruled, in your case or in the other case is sustained. So those rulings are very common. Those disputes are very common. Discovery disputes are very common between litigants. So, but there's no reason to panic. If you see an order coming to you that the objection was overruled and the discovery has to be provided. Again, because there are ways you can try to mitigate any potential exposure. Something also that could take place, and it's not particular ruling, but it's important to note here, is when you have a piece of evidence that shows up that your attorney was not aware of, but it shows up in discovery and it's not in your favor. That has happened often, unfortunately, but it does happen. Whether it's a particular email that you forgot or the client forgot, something your attorney was not aware of, a fact. And if you recall in prior episodes, I stressed the fact that it's important to tell your attorney the good, the bad, and the ugly. To tell everything to your attorney, even if it's bad news. Do not withhold information from your attorney that is relevant to your case, because then your attorney will be able to assess how to handle that piece of information. Your attorney will be able to say, okay, this is bad, but let's handle it, or this is really not as bad as you think it is. But the worst thing that could happen for your case is that in the middle of a deposition, there's a question that is asked of you, and you make an admission which your attorney was not aware of that particular fact. Or they present an email, you making an admission or incriminating you in a fashion that you may lose the case, and your attorney was not aware of that existence of that email. It just creates all kinds of problems later on, and that could certainly affect your case. And that will be a self-inflicted error simply because it could have been avoided by having your attorney, giving your attorney the information necessary to handle that piece of information. So even if you believe it's not too important to your case, share with the attorney. Let the attorney make the determination how important that email is, how important that witness might be. That's what we do, assessing the importance of the information to help your case. So I cannot stress that upon you, how important it is to share that information with your attorney, because that, in essence, can lead to summary judgment. It can lead to all kinds of different rulings later on. And if it's something in an interrogatory that you put under oath and then find out that perhaps it was not true, then you can be subject to sanctions, and that's something that you certainly want to avoid. Another thing you might deal with is, and unfortunately it does happen, is delay tactics by the opposing side. Whether it's delays on providing discovery, whether it's delays on responding to making themselves available for depositions, in essence, running the clock. Years past, you could do that. Now it's a little bit more difficult because we have a very strict case management order now that is imposed upon in Florida courts, especially in federal court. It's been like that all along, but Florida courts now have a very strict deadlines that we have to abide by. So it's very difficult to run the clock now or to create delay tactics by the opposing side by not being available for discovery, depositions, not responding to discovery, not providing complete discovery responses. There are things that we can do to address that, which is through motions to compel and sanctions, and vice versa. If your attorney asks you for information, asks you to be available for a deposition, it's important that you also cooperate with your attorney and don't wait till the last minute to provide information that he or she needs in order to help your case. It's not easy to do things at the last minute. It's actually not advisable to do so. Another thing that happens that often takes place, which frustrates clients, is when, say you get sued, you get the lawsuit dismissed. Then they amend the lawsuit and start all over again. So, well, I thought we won the case. The lawsuit was dismissed. Yes, but they amended the pleadings, and now they were able to overcome that initial dismissal. In essence, you're starting the case again because then you got to either motion to dismiss again or you got to do what is called answers and affirmative defenses. So it's frustrating because then you're, in essence, reliving the lawsuit at various stages. It is very common throughout the course of the case that the lawsuit gets amended 2 or 3 times. Now, there are deadlines when you can amend the pleadings, but it's very common. And you have to be able to deal with that It could be amended because of newly discovered evidence that was not available initially. It could be amended because they want to add an additional party to the lawsuit. There are many different ways they want to amend the lawsuit. And the same thing with affirmative defenses. Lawsuits are amended often before they actually go to trial. And in fact, the lawsuit that was initially filed might be slightly different from the lawsuit that will be the one going to trial. The facts are somewhat the same, but some of the theories of law or the counts might be added or removed, depending how the case goes. I want to talk about settlements versus trial decisions. And that's really, I think they're more about whether you want to stay in a lawsuit or you want to settle the case. Every single time you have a ruling, every single time you have a deposition or answers to interrogatories or production request, you have the ability to make decisions on that case, because litigation is a dynamic process. It's not a linear process. It's not a fixed process. It changes every time with every piece of information that we receive or we send, every new discovery that we make. So it's important to have that reality check. What are you suing for versus what is the cost of litigation? And that's important to know, and it's important to talk to your attorney about this. The attorney cannot give you a 100% prediction what it's going to cost. The attorney can give you a range of what he expects that it will take based on the number of witnesses, based on the number of the extent of the lawsuit, how many counts you have they're suing, number of parties, how long it will take for the trial to take place, the complexity of the case, the number of documents that have to be reviewed. All that is part of that equation to determine, okay, this is the amount of time that it's going to take and how much effort it's going to take to get this case to trial. But also understand that a lot of our work that we do is generated by the other side and vice versa. And I'll give you an example. So if I'm sending 25 requests for production of documents, 25 different requests. Say for example, it's a breach of contract case. I ask for all the communication between the parties, email communication, text messages. If I'm asking for an accounting, I ask for all the bank records. I ask for the financial reports. I ask for anything, communication with witnesses. And I ask information about all the allegations of the complaint. And ask for the same thing, 25 interrogatories, maybe 25 requests for admissions. I'm creating a tremendous amount of work, legal work, for the other side. And I'm certain they're going to return the favor as well. That they're going to submit a tremendous amount of requests for us. They're going to submit a tremendous amount of production requests, admissions, interrogatories, so that you will have to provide and you'll have to answer. So all that information has to be gathered, organized, and submitted in a format that the other side actually can understand it. Has to be, indexed, and we have to produce it in that format as well. So that work is done by the paralegal, if the law firm has a paralegal. If not, it's done by the attorney. It's better if the paralegal, my paralegal, organizes the material and it works with the client in preparing those first drafts. It's a lot more cost effective for the client to do so versus me trying to do that at my hourly rate. So it saves money to the client when the paralegal does that first initial set of drafts, and then I go ahead much later, begin to look at that and prepare the final response and approve it for submission. So a lot of the work is really prepared, is done. A lot of the legal work that I will do as litigator is generated by the requests from the opposing counsel. That includes deposition of witnesses. That includes deposition of parties. Sometimes we got to hire experts in our cases. So a lot of work has to be done in preparation, and that's the reason it's so expensive. So talk to your attorney about that particular cost and understanding the risks and the costs and the time involved in the litigation and what are your objectives in the case. If you're the one being sued, clearly you got to defend it. You have two options. You got to defend the lawsuit. Well, you have three. You have to defend the lawsuit, you can settle, you can default. Those are the three options you have. Default meaning you decide, I'll accept the judgment, and then we'll move on, maybe file bankruptcy, but those are the three options. If you're the one suing, then you decide, okay, what are my objectives for the lawsuit, what I'm trying to recover versus how much it's going to cost me to pursue this. And that's an individual decision you make with your attorney. Witnesses sometimes back out, meaning they don't show up to depositions. The way you can force them, you can compel them to show up to a deposition through a court order, but also sometimes they show up to trial. So a lot of things happen in the course of litigation that will not go your way. You also have situations where parties sometimes forget their testimony or do not tell the truth. It happens. So it is a very fluid type of process, and we try to obtain the best available evidence available through depositions and through written interrogatories and subpoenas, but it's not a perfect system. So I want you to understand that the attorney's skills and experience is essential. It's very important here with dealing with litigation and the attention to detail. And I mentioned already before the attorney-client communication issues, which is to tell your attorney the truth, even if you feel that it's significant or a detail, share it with your attorney. Oftentimes when I talk to my clients about the first part of the case, we get information. Then as we're discussing other matters, I hear something that said, I forgot to tell you. Or I look at an email and I said, well, what about this email? What happened here? I don't think that was important. I'm like, well, actually, yes, I think it's important. I can do something with this. Whereas an admission by the other side, maybe it's a witness that we did not know that we had available to us. So there are a lot of things that we can do and we look for as litigators that, you not doing this for a living, you're not going to be able to understand or do. So allow us the opportunity to at least make the determination whether or not this particular fact is important for your case or whether or not this witness is important to your case. Let us do that for you. So just to recap, litigation is a long process. In Florida, it takes between 12 to 18 months to get a case resolved to trial, sometimes even longer depending on the availability of the court and maybe delays for many different reasons. It is important for you to stay calm as much as you can, understanding that we recognize you're the one being the litigation, but it's a process. And trust the strategy and trust the process. And also work with your attorney on making sure that you're on the same page as to the strategy and your goals. You and your attorney must be on the same page throughout the course of litigation. If anything changes, it's important for your attorney to know. So the attorney can change strategies, pivot, or make adjustments along the way. But it's important that you and your attorney need to be on the same page in the course of the litigation because your attorney is going to be sitting next to you at trial. If it goes to trial, which many cases now are going to trial, but your attorney is your guide. So it's important to work with your attorney in this process, but recognize that sometimes things will not go your way. And I remember in a mediation that I had, I think it was Judge Rosa Rodriguez said, in this type of case or any type of court case, you will have a winner, you will have a loser. There will be no draw here when you're going in front of a court, a jury trial or a bench trial. So it's important to know that. And if you do not settle the case, then you will end up, either in one side or the other, and there are no guarantees. No attorneys can guarantee you what the result will be. One thing I failed to mention is financial preparation. It's important that also you financially prepare yourself for unexpected surprises in the case, whether it will be a witness that you'll have to you were not aware of that you will have to depose, or perhaps a witness that the other side wants to depose, that you have to show up anyway and do the cross-examination or cross-deposition of that witness. There are unexpected costs in litigation, but you have to the extent your attorney can advise you and give you a forecast of what to anticipate, it's important to ask those questions as well. Your attorney keep you informed in advance if there's anything anticipated that you were not planning to spend on, to let you know in advance, so that way you can be prepared for that. The financial preparation is essential to have a successful litigation process. Thank you for listening to this episode. I hope it was helpful to you. As always, if you want to reach me, my email is richsierra.com. My website is floridasmallbusinesslegalcenter.com. We're on YouTube at youtube.com/@RichardSierra. If you want to call me, my phone number is 561-409-0364. Remember that if you're in a litigation, please do not go at it alone. Get an attorney to help you. I suppose you're trying to defend the lawsuit by yourself. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.